Hi, this is Erica Merrill, and I'm the founder of Perfect Legal Video. I'm very excited to have with us today Attorney Nicole Reeves Lavallee. Today, we are going to be talking about something called a standing order, and we're going to find out all about it and what you need to know. Thank you so much for joining the show today, Nicole. Welcome.
Thank you for having me.
So, what's a standing order?
A standing order is basically it's an order that is issued by the court saying if you have certain things, you need to file them in a certain way and you need to follow these procedures. So they're different than evidence and they're different than the rules of law. They're incorporated in them, but they're specific to a certain set of motions that you're going to be drafting up.
So, do all courts have standing orders?
Yes, they do. All courts have different standing orders. Some of them are identical in civil court as they are in probate court. Some of them are different. So each court is going to have a bunch of standing orders and you have to follow them. But again, the rules of evidence are going to be overall. Then we're going to have these specific standing orders that pertain to your particular case based on the courtroom that you're in.
So, I mean, it might seem like a silly question, but some people may be wondering, why are these standing orders needed?
They're needed essentially because you're going to have an order that was entered or a judgment that was entered by the court and something went awry. Either I don't agree with the decision and judge, you need to open the case, or judge, you need to reconsider because you didn't have all the facts, or hey judge, I failed to show up for the hearing, but I have an excuse like I was in the hospital. So there are going to be some kind of extenuating circumstances that you can kind of go, hey, you judge need to look at this again and really kind of have all the facts before you can make a decision.
I mean, sure, that makes a lot of sense. The only motion that I remember is the motion to suppress. And, I used to call that the motion to surprise. And I know there's a lot of other motions. What types of motions are we looking at here?
So you're going to be looking at, again, court specific, but you're going to be looking at a motion for reconsideration, which is judge, reconsider something because, again, I didn't have all the facts or I didn't show up. A motion for relief from judgment. Judge, how could you possibly rule that way? You missed something, or I didn't show for court, or something that says, hey, you need to vacate that order or that judgment because something happened. It could be a motion to vacate. It could be a motion to clarify the judgment. So there's a lot of different technical terms, and of course, each court is going to have something different. But it's basically saying, judge, there's an order out there and something needs to change, so I need to get in front of you. It also could be a motion for a new trial. So if there's new evidence that came to light a week after your trial, you want to get that in front of the judge before a decision was made. I actually had one of those, and it was very interesting because mom testified that she was working for Jane Smith. And my client goes, I don't know about that. We did our trial and we went about our business, and he went home that night and he looked it up. And of course, Jane Smith was a really complicated name, but he looked it up and goes, yeah, the woman that he was working for, she's dead. Here's her obituary. So we used that and we said, judge, we need to reopen the case. And we reopened the case and we heard evidence about how she wasn't working for the dead woman. And the judge actually did find that, this mother was perjuring herself in that particular case. So it is definitely a tool that is accessible, but it does have limitations.
So that's interesting. And it sounds like a motion is a decision that needs to be made like many other things that happen in court. And they all have their own time frames, I'm sure. Are all the time frames different to get the decision depending on which motion it is? Or is there just a standard time frame?
So again, you're going to look at the court and see which court you're in and what their rules are. For example, in probate court, we filed a motion for relief from judgment. We then have to wait, and that applies to any of the standing orders in probate court, but we then have to wait 20 days. The 20 days is for the opposition, if any, to be filed by opposing party. After that period of time, then the judge will take a look at it and make a decision. So there could be time limitations on terms of when you're going to get a decision, and it is strictly up to the judge as to whether or not the judge is going to hear oral arguments or if they're just going to rule based off of your motion itself. So each court is going to have different rules as to how it's going to be submitted to the court, when it's going to be submitted to the court, and what time frame the other party has to object.
So do I get a hearing before the court, before the judge?
Again, that all depends on which court you're in. In probate court, it is at the sole discretion of the judge. The judge will look at it, will look at your motion, will look at your opposition, will maybe recall your testimony, or maybe they'll have to listen to the audios of your testimony at trial. After we have all of that, at that point in time, the judge will say, I'm going to rule just on this motion, or no, I need to have more evidence, in which case the judge will order a hearing date.
So what happens if the motion is denied? Do you get to start over?
No. What's going to end up happening is that your case is done. So if it's on a judgment, your remedy at that point in time is to appeal the decision. You can take that motion for relief or reconsideration or whatever it is and appeal both that decision as well as the underlying judgment. If it is a temporary order, I'm going to tell you, chances are, unless it's something grossly negligent done by the judge, you're going to have to live with it until you have final hearing on the judgment. So hopefully that temporary order isn't going to be a severe hindrance. And the prime example of that is going to be if you have somebody that parties are fighting over custody and dad gets custody and mom files the motion and it's denied. Well, then guess what? Dad's going to have custody. So he's going to kind of have that upper hand when he goes to final pretrial. Now, again, there may be things that happen in the meantime that change the judge's opinion, but you're going to have to start with that premise is dad has custody until such time that a further hearing or order comes down.
I mean, this has been very eye-opening. It's good to know about the process and how it differs from court to court. You really have to find that out ahead of time. And so it's really good information. Is there anything that we may have missed in today's interview about standing orders that you thought of while we were going?
I think the biggest thing is don't try to do it alone. You are not going to be successful. I have never seen a pro se litigant file a standing order motion and have it done properly. Because the biggest thing with any of these standing orders is if you do not follow the standing order to a T, then the court can reject it. So they won't even hear the motion. They will deny it. They won't allow it. They will do nothing with it. They will literally throw it back to you and go, this is improper, fix it. And so now if you don't know what you're doing and you've mailed it into the court and it comes back rejected 2 weeks later, you've lost that 2 to 3 weeks getting it together, and now you're kind of back at square one. And again, depending on what those issues are that you want resolved, they could be huge. So really, it's not something that you want to take lightly. There are very specific rules, and even one of them will get a kickback and you will not get any decision.
And that is too bad because, I mean, these court decisions really affect your life. And so I think anything that has to do with the courts or being in front of a judge or trying to fix something that needs to be fixed, especially with family law, you need a good attorney. So if you need a good attorney, definitely give the law offices of Nicole Reeves Lavallee a call. They are spectacular. They know what they're doing. They're empathetic, but they're all business at the same time, and they can give you great strategies to, get the best outcome for your family. And so, I know that there's a lot of people that really appreciate the work that you do, Nicole.
Thank you. I really hope that I'm helping everybody that I touch and I come into contact with.
Absolutely. So thank you so much for joining us today, Nicole. We really appreciate your time, and we will look forward to seeing you again very soon.